Yes, the secret documents case was fun while it lasted, but Judge Eileen Cannon has killed the prosecution of Donald Trump over the national security and classified documents that he allegedly took from the White House to Mar-a-Lago. It was a lot of little things, many of which were defensible on their own, but taken together, Judge Cannon has made sure that a prosecution before the election is impossible. Chaos lawyer Liz Dye explains how the dirty deed was done.
Thanks, Devin. When Donald Trump was indicted in June of 2023 for taking national security documents out of the White House and refusing to give them back, he asked Judge Eileen Cannon to set a trial date of never. The government responded that that is not a thing under the Speedy Trial Act, which requires the court to set the case for trial on a day certain. And so the court duly did set a date of May 20th, 2024. But on May 7th of this year, Judge Cannon changed her mind and decreed that the finalization of a trial date at this juncture would be imprudent and inconsistent with the court's duty to fully and fairly consider the various pending pretrial motions before the court, critical classification issues, and additional pretrial and trial preparations necessary to present this case to a jury. Translation? There are just so many motions that haven't been ruled on yet that she has no choice but to postpone the trial. Gosh. I wonder who created that backlog of motions by failing to rule in a timely fashion. It's a mystery. In reality, Judge Cannon has undermined this case from the beginning, both by taking forever to adjudicate every single motion and by treating every issue, no matter how mundane, as if it is complex and novel and requires multiple rounds of written briefing and oral argument. The result is a case which will go to trial in 2025, if ever. And on top of that, she's teed up a bunch of issues which could derail the case even further, particularly with respect to classified documents. This case isn't about classified documents per se, but the fact that Donald Trump walked out of the White House with hundreds of classified documents in his luggage is what kicked it off. For a full year after Trump left office, the earnest civil servants at the National Archives cleared their throats politely about all the presidential records which had gone missing on January 20th, 2021. Then, in January of 2022, Trump returned 15 boxes of government property, including a love letter from North Korean dictator Kim Jong-un, Barack Obama's handwritten note to his successor, an Air Force One model plane, and a commemorative bollard from the border wall that Mexico was going to pay for.
And then we fell in love, okay? No, really. He wrote me beautiful letters.
But interspersed with those items were upwards of 100 documents bearing classified markings, including some which were designated as top secret or part of special access programs available on a need-to-know basis to a minimum number of cleared employees. The archivists, who were certainly not cleared to see the stuff they'd just been handed, freaked out and contacted the Justice Department. And the DOJ turned its attention to getting back any missing government property, as well as investigating whether any national defense information had leaked out while Trump was storing special access program documents in his pool shed. The DOJ secured a grand jury subpoena demanding that Trump return anything in his possession that bore a classified marker. But Trump, who got elected in part because he'd accused Hillary Clinton of being careless with classified emails, didn't want to give that stuff back. So instead, he got his lawyer, Christina Bobb, to sign a certification saying that they'd searched Mar-a-Lago high and low, and they've turned all that stuff over. But that was a lie. According to the indictment, Trump sorted through the boxes and culled the documents he wanted to hang on to before his other attorney, Evan Corcoran, showed up to search the premises. So when the FBI knocked on the door with a warrant in August of 2022, they discovered thousands of government documents with some 300 of them bearing classification markings. Trump challenged that warrant in court and had the good fortune to land in front of Judge Cannon. She managed to engineer several months of delay before being brutally smacked down by the 11th Circuit in December of 2022. 7 months later, Trump was indicted for retaining and failing to deliver national defense documents under the Espionage Act, conspiracy to obstruct justice, and making false statements. Once again, he landed back in front of Judge Cannon. The presence of classified evidence was always going to add an extra layer of complication. And some of the earliest signs that this case was going to go off the rails involved that classified evidence. One of the first things that happened in this case was that the government moved for a protective order governing the classified discovery materials. Trump objected to being forced to examine and discuss classified documents in a sensitive compartmented information facility, aka a SCIF. The guy who famously blabbed about a North Korean missile launch on the lanai at Mar-a-Lago with the Prime Minister of Japan did not want to have to travel to a secure facility as is required by law. Instead, he wanted the court's permission to keep that stuff with him at Mar-a-Lago or possibly at his club in Bedminster, New Jersey. His lawyers argued that the protections afforded to our nation's leaders after they leave office and the uniqueness of the location of President Trump's residence meant that their client, who is charged with storing stolen government documents in his country club's shower, should be trusted to store classified evidence at his country club, just not in the shower. Unless the shower is also a skiff. At the same time, Trump's valet Walt Nauta demanded that he too should be allowed to see all the top secret evidence. Remember, Nauta and the groundskeeper Carlos de Oliveira are not charged with violating the Espionage Act. Their defense does not rest on what was in the boxes. It could have been nuclear plans or souvenir White House cocktail napkins. It don't make any difference. They don't need access to those documents, and in fact, the Classified Information Procedures Act, better known as CIPA, allows the court to withhold classified evidence from defendants in the interest of national security. These issues are no-brainers, and yet Judge Cannon demanded full briefing and oral argument and then took 7 weeks to rule. She did eventually get it right. Trump was barred from perusing classified evidence on the golf cart between holes, and his henchmen won't be allowed to see the war plans their boss allegedly swiped from the White House. But it took the judge until September to figure it out. And that's not the only weird, slow thing she did here. CIPA Section 4 allows the government to request that the court withhold some classified evidence from the defendant in the interest of national security. The court holds a hearing ex parte in chambers, that is, the defendant doesn't get to be there. Because if the nature of the document were disclosed to the defendant, it would defeat the whole purpose of the law. After multiple hearings and hundreds of pages of briefing, Judge Cannon finally decided that Trump could not attend the Section 4 hearing. But by then, it was February 28th, and the original October 17 hearing date was deep in the rearview mirror. The judge played a similar game with respect to CIPA Section 5, which obligates defendants to declare what classified evidence they intend to use at trial. That deadline was originally set for November 17 of 2023. But on November 10, Judge Cannon took it off the calendar and even blamed the special counsel for gumming up the works by spending so much time arguing about CIPA Section 4 and the issue of the skiff. She also yelled at the prosecutors for not building a skiff near her courtroom in Fort Pierce, Florida, before filing the indictment. An indictment which could well have landed in another courthouse entirely. She put the issue off until March, at which point it was clear there was no way for this trial to go forward on May 20th. But Judge Cannon didn't cancel it officially until the first week of May, which looks an awful lot like squatting on the calendar to block anyone else from scheduling a Trump trial during that period. In April, the judge finally set a new date of May 9 for Trump to turn in his Section 5 homework. After which, Trump's lawyers immediately asked for another postponement, complaining that they were far too busy with his New York criminal trial to meet their obligations in Florida, even with the 6-month delay they'd already wrangled from the court. They complained that the May 9 deadline would deny President Trump his constitutional right to participate in critical aspects of his defense and infringe on its constitutional right to counsel of his choice in this case. The government noted that it was Trump's choice to hire the same lawyers to represent him in multiple overlapping criminal cases, and if those lawyers overcommitted themselves, that was hardly the court's problem. But Judge Cannon didn't see it like that, and so she moved the Section 5 deadline yet again, this time to June 17th, unless that date turns out to be inconvenient for the guy who appointed her to the bench, in which case, YOLO.
Now, I'm sorry to interject, but if you took a bunch of national security documents from the White House, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If your loved one is suffering from mesothelioma, because asbestos exposure can take decades, if you've suffered from a data breach, especially if you got one of those data breach letters, or were involved in a car crash or just about anything else, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process so that you maximize your recovery and you maximize your options. So just call the number that's on screen or click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is down below.
Judge Cannon claims that she has no choice but to postpone this trial because there are at least 8 substantive motions which have yet to be resolved. But she fails to mention that they're not resolved because she herself has yet to resolve them. Back in February, Trump filed a motion to dismiss based on presidential immunity. This one has the potential to derail the case indefinitely, since Trump will be entitled to an immediate appeal if the court denies it. That's why Trump isn't on trial in D.C. right now for election interference, because when Judge Tanya Chutkan denied his motion to dismiss that case, he got an automatic stay while he appealed the immunity decision to the D.C. Circuit Court and then to the Supreme Court. But that case actually involves stuff that happened in D.C. while Trump was president. How could hiding government documents in the shower of his private club in Florida years after he left the White House be part of his official duties? Well, Trump's theory is that he designated a bunch of classified documents as personal before leaving office, and that this designation was part of his official presidential duties. The problem is that Trump only started making this claim in 2023 after the Mar-a-Lago raid. In fact, in 2022, he called those documents presidential records in his own public statements, and so did his lawyers. But in 2023, Trump's pal Tom Fitton, head of the conservative lobby group Judicial Watch, told him that he never had to give anything back to the government if he called it a personal record.
No one but the president gets to pick what's presidential records. No one but the president gets to pick what are personal records.
Fitton is not a lawyer, but his shop once sued the National Archives to make the agency go seize audio tapes Bill Clinton made for his biographer. Judge Amy Berman Jackson, a trial judge in D.C., said that she had no authority to force the archives to do that, from which Fitton inferred that the president's decisions about record retention are unreviewable by any court.
We can't come in there and manage his day-to-day operations. We can try to make sure that certain records that are created on behalf of the American people that document his activities officially are kept, a la the Federal Records Act. But we can't come in and say, oh no, you should have kept that one as a presidential record and you can't have that one as a personal record. Because that gets too much into the heart of the operations of the White House, which constitutionally is a separate branch of government. But they've blown all that up right now by pretending they can go in and raid his home based on this very dispute. Unbelievable.
Compelling. Trump made similar arguments in a motion to dismiss under the Presidential Records Act, claiming that the PRA conferred unreviewable discretion on him to designate the records at issue as personal. As such, President Trump's possession of those records was not unauthorized. As the special counsel points out, that would mean that a departing president could unilaterally convert classified government records containing the nation's most closely guarded military, diplomatic, and national security secrets into his private possessions, and then disclose those secrets to a foreign adversary, post them on the internet, or sell them to the highest bidder. By that logic, Trump could simply declare the entire National Security Archive a personal record, walk out of the White House with it, and sell it to Vladimir Putin, and there would be nothing anybody could do about it. Or he could not declare it a personal record. He could just steal it and say that the theft itself qualified as designating something a personal record under the PRA. In fact, Trump's lawyers made this exact declassification by theft claim at the 11th Circuit, where they argued that because the records were not provided to the archives at the end of his presidency, the seized records are presumptively personal. Under this reading, the FBI lacked any authority to direct the seizure of President Trump's personal property, and the warrant should be tossed out. Trump repeated this claim to CNN's Caitlin Collins in February.
You have the Presidential Records Act. I was there and I took what I took and it gets declassified.
That simply cannot be right. The Presidential Records Act was passed to ensure that Richard Nixon could not destroy evidence of crimes associated with the Watergate scandal. The law would be meaningless if Nixon could have gotten around it simply by saying, "Oh, this is my personal property." The 11th Circuit explicitly rejected this argument back in 2022 when it ruled that Trump could not challenge the search warrant because he had no possessory interest in the documents at issue, so he did not suffer a cognizable harm if the government reviewed the documents he neither owns nor has a personal interest in. But Judge Cannon seems alarmingly receptive to the claim that Trump magically transformed the government documents into personal records by tossing them in his luggage on the way out the door and stashing them in his pool shed. In March, she spontaneously directed the parties to draft instructions for the jury, which presuppose that the president has sole authority to decide which records are personal and which are presidential, and that no court can review that decision. Worse, she ordered them to work from the premise that an outgoing president's decision to exclude what he or she considers to be personal records from presidential records transmitted to the National Archives constitutes a president's categorization of those records as personal under the PRA. So under this theory, the act of swiping government documents, no matter how sensitive, would automatically convert them to personal records. The special counsel's office hit the roof, since that would be functionally an instruction to the jury to acquit. Jack Smith demanded that the judge say well in advance of the trial whether she intends to use this crazy jury instruction so that he'll have time to seek emergency review by the 11th Circuit. Because once the jury is sworn in, jeopardy attaches and it will be too late to appeal. Trump will not be tried again. Judge Cannon was indignant at the unprecedented and unjust request that she rule on the issue she herself had posed, and she still hasn't ruled on it. She just threw it on the pile of wrenches to throw in the works at a later date. In fact, there are any number of wrenches the judge is keeping in her back pocket here. Do judges' robes even have pockets? In February, Trump filed motions to dismiss on grounds of presidential immunity, unconstitutional vagueness, the Presidential Records Act, selective and vindictive prosecution, the illegal appointment of the special counsel, and for prosecutorial misconduct and due process violations. He also filed a motion to compel a mountain of discovery from the government on the theory that the entire executive branch is part of the prosecutorial team, and thus he's entitled to go digging around in internal White House communications. Nauta and De Oliveira have filed several motions of their own. So far, Judge Cannon denied Trump's motions to dismiss under the PRA and for vagueness, but that leaves a whole lot of motions undecided. And each of those motions has the potential to derail this case entirely. For instance, the motion to dismiss on the basis of presidential immunity can be appealed immediately. That's how the DC election interference prosecution got hung up, because Trump lost his motion to dismiss on immunity and appealed to the DC Circuit, which had the effect of freezing his case. And it's still frozen as we await a ruling from the Supreme Court. So if and when Judge Cannon denies Trump's immunity motion in the documents case, he will run exactly the same play here. In the meantime, the judge has scheduled a June 21 hearing on Trump's motion to dismiss the indictment based on the unlawful appointment and funding of the special counsel. This is a long-shot effort premised on the theory that special counsels are illegal because they aren't confirmed by the Senate. In fact, Title 28 of the U.S. Code, Section 515, refers to any attorney specially appointed by the Attorney General under law who is empowered to conduct any kind of legal proceeding, civil or criminal, including grand jury proceedings. And the Code of Federal Regulations authorizes the AG to appoint a special counsel when an investigation or prosecution would present a conflict of interest for the Department of Justice. Nevertheless, Judge Cannon is not only holding a hearing, she has invited outside parties to file amicus briefs and even to make oral arguments on that motion.
Wait, what? A trial judge is inviting oral arguments from amici at a motions hearing? That's crazy.
I know. As for the motions to dismiss for selective and vindictive prosecution, well, both of those are hard to prove as a matter of law. Selective prosecution is when the government singles you out for worse treatment than people similarly situated to you. And vindictive prosecution is when the government charges you to punish you for exercising a legal right. Trump's theory is that President Biden is vindictively unleashing the Justice Department on him to punish him for running for office. He claims that Biden subliminally instructed Attorney General Merrick Garland by leaking to the New York Times his secret wish that Trump would be indicted. In fact, the Times reported that in late 2021, long before Trump was a candidate, Biden confided to his inner circle that he thought Trump should be prosecuted. But Biden never communicated his frustrations directly to Mr. Garland. To prove selective prosecution, Trump points to a long list of comparators who mishandled classified documents and were never charged. That list includes Joe Biden, Mike Pence, Hillary Clinton, James Comey, and even Trump's own COVID response coordinator, Dr. Deborah Birx. Exactly none of these former officials refused to return documents for months, let alone to fight a grand jury subpoena. And yet, Judge Cannon seems extremely receptive to this argument. So receptive, in fact, that she's not even calendaring a hearing on that motion at all. Instead, she's holding a 3-day hearing beginning June 24 to allow Trump to argue that he should be able to compel discovery so he can go rooting around for evidence that President Biden is secretly controlling the prosecution. And then he'll get another round of briefing and another hearing and another round of briefing and another hearing and another round of briefing and on and on and on and on. To be clear, lots of judges take a long time to rule on motions. It's not that weird. But lots of judges are not presiding over a case with national security implications in the lead up to an election. And Trump's allies certainly perceive Judge Cannon as friendly to their cause. Rolling Stone's Aswan Subsang and Adam Ronsley reported recently that Cannon's delays in legal reasoning have become something of a running joke among the upper crust of Trump world, with various political advisors and campaign staff Lawyers and media figures in the ex-president's orbit remarking on how obviously and helpfully Cannon has been in the tank for Trump. His advisors call her my favorite member of the Trump campaign and a godsend. Whether Judge Cannon is sent by God or someone else, she'll rule on all those motions when she gets to it, and not a moment sooner.
So there you have it. We can put this case, reputed to be the strongest against the former president, to bed at least until after the election. Unless, of course, he wins, then it just goes away. But if that makes you want to run and hide, today's sponsor, Incogni, can help. Because Incogni is my favorite tool to help with online privacy, in case you've ever said anything unkind about the dear leader and are worried about reprisals. Incogni removes your online personal data from data brokers. Data brokers sell your info to the highest bidder, resulting in loss of privacy, phone calls, texts, spam emails, and much, much worse. But Incogni will reach out to these data brokers and make them take your personal info down. If these brokers fight back, which I've seen them do, Incogni will take care of that too. It's a great way to cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, we've all Googled ourselves, it's okay to admit it, but you might have seen that there are websites out there that have tons of info on you. These sites can provide in-depth records including information such as home addresses, contact details, license plate numbers, and financial information. And these sites can expose you to a wide range of dangers, from scams and identity theft to online harassment and stalking. Every year, both the number and scope of data breaches worldwide are rising. And according to the 2022 annual data breach report by the Identity Theft Resource Center, the number of victims has gone up nearly 41.5% from 2021. But Incogni gets that information down and out of the hands of scammers and identity thieves. All you have to do is give them approval to work on your behalf, and Incogni conducts repeated, ongoing removals, because even if a broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. When I signed up, it was fascinating for me to look at my own dashboard and see that I was on hundreds of data brokers' lists. So I guess it was no surprise why my email inbox was full of junk and my phone was constantly ringing with scam calls. Here's my own Incogni dashboard. It shows that these 3 sites potentially had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers might have had data including my contacts, financial information, and health data. But it's seriously relieving to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. You can click on the link below to get 60% off of Incogni when you use the code LegalEagle. So get an exclusive 60% off discount by just clicking on the link that's on screen right now or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.